A company's most valuable asset wasn't its code or its patents. It was a blueprint for how to run a business. And a rival allegedly got a copy. In the high-stakes world of HR tech, Rippling had built something unique. A single, unified system to manage a company's entire workforce. This operational playbook was the engine behind its explosive growth, pushing its valuation to $16.8 billion. But in 2025, a legal filing made a shocking claim that competitor Deel had illicit access to that system, reverse engineering the very core of its business. The allegation suggested a new kind of corporate espionage, one where the prize wasn't a document, but the entire operational brain of a unicorn. To understand what was allegedly stolen, you first have to understand what was built. Founded in 2016, Rippling was built on a novel premise. Instead of disparate software for human resources, IT, and finance, the company engineered a single, unified data layer to manage all employee operations. The core innovation was connecting the entire employee lifecycle, from onboarding and payroll to device management and building access, into one automated workflow. This structure did more than streamline processes. It generated a highly specific and valuable operational dataset, a complete record of an employee's journey through a company. By creating a single source of truth for all workforce data, Rippling had constructed a powerful, centralized operating system for business. The market validated this approach with staggering force. By 2025, Rippling surpassed $1 billion in annual recurring revenue, reporting a 78% year-over-year growth rate. A $450 million Series G funding round cemented its status, pushing its valuation to approximately $16.8 billion. The subsequent launch of Rippling AI amplified this advantage, turning its unified data layer into an executable action engine. Unlike competitors with bolt-on AI solutions, Rippling's system could translate commands directly into cross-departmental actions. However, a system this integrated and complex presented a unique strategic challenge. To effectively demonstrate its superiority and displace incumbents, its sales force required an encyclopedic knowledge of rival platforms. This necessity for deep competitive intelligence set the stage for a relationship built on a fragile foundation of trust and information access. The alleged intrusion into Rippling systems was not the work of an external hacker breaching a firewall. According to legal filings, the attack vector was far more insidious, a human operative. The core of Rippling's lawsuit claims that its competitor, Deel, circumvented digital defenses by allegedly planting a mole within the company's own workforce. This tactic inverted the modern corporation's model of trust. The very access granted to an employee, a prerequisite for daily work, was allegedly weaponized to serve a rival. In the hyper-competitive HR technology sector, where speed and proprietary knowledge are paramount, this represented a profound violation. The conflict, which intensified publicly in 2025, moved beyond standard corporate litigation. Later reports from major financial media, citing a related Department of Justice probe, elevated the dispute from a private squabble to a matter of federal scrutiny. The allegations transformed the abstract risk of competition into a tangible sense of paranoia, where the threat was not outside the walls, but already inside, with full credentials. For Rippling, the immediate challenge was no longer just protecting its data, but determining the full scope of the breach. The legal filings would soon provide a forensic trail, outlining exactly what information the alleged operative was instructed to collect. The forensic trail detailed in Rippling's legal filings did not reveal a single, dramatic data heist. No smoking gun download at midnight. Instead, it allegedly painted a picture of slow, systematic extraction, death by 1,000 clicks. The primary target was not source code or a patent. It was the company's living, breathing, competitive playbook, its operational brain, granular pricing models, prospective client lists loaded with direct contact details, internal sales objection scripts calibrated to counter every argument a rival, like Deel, might make in a deal. This was corporate espionage redefined for the SaaS age, where the prize isn't a static blueprint, but the day-to-day intelligence required to steal market share, quarter by quarter. Uncovering this activity meant turning the tools of modern enterprise management inward. Digital forensics teams reconstruct a user's journey through server logs, internal messaging platforms, CRM software. Every keystroke, every downloaded file, every search query. Each one becomes a pixel in a larger image, and together they form a meticulous timeline of an operative's alleged actions. As Rippling filed its lawsuit alleging data espionage and Deel responded with a countersuit, a parry that signaled this would be a war fought on multiple fronts, this digital evidence became the backbone of the complaint. A subsequent Department of Justice criminal probe into Deel, reported by major financial media, further underscored the gravity of what the logs allegedly revealed. With the forensic evidence assembled, the conflict was set to move from network servers to the courtroom, where it would test the legal boundaries of what a trade secret actually is, and how far a company must go to protect it. The courtroom became a multi-front war. Rippling's civil lawsuit alleging espionage was met by a countersuit from Deel, creating a complex web of litigation. Compounding this pressure was the shadow of a reported Department of Justice criminal investigation into Deel, elevating the stakes beyond mere financial damages to potential federal charges. This salvo of motions forced a critical legal question into the spotlight. Could dynamic, real-time sales intelligence be classified as a protected trade secret with the same standing as source code or chemical formula? The answer would carry existential weight, capable of validating or destroying a company's competitive advantage. Yet even as legal costs and risks mounted, the public-facing battle for market dominance accelerated. Both companies were forced to navigate this existential threat while managing hypergrowth. Deel, specifically, projected an image of business as usual, acquiring the software procurement firm SaaStrify and securing a major sleeve sponsorship with a global sports franchise. This parallel track demonstrated a critical reality of modern corporate conflict. The fight in the courtroom is inseparable from the fight for public perception and market share. The challenge was no longer simply to win the case, but to outmaneuver a rival on all fronts simultaneously, proving to customers and investors that the underlying business remained sound and unstoppable. The Rippling versus Deel dispute has redrawn the map of corporate vulnerability. It argues that in a modern SaaS enterprise, the true crown jewels aren't just patents or source code. The most lethal weapon is dynamic, operational intelligence, real-time pricing algorithms, confidential client lists, and the internal scripts for overcoming sales objections. The alleged theft of this playbook marks a critical shift, a shift in what we're willing to go to war over. This conflict, which involves ongoing litigation and should not be construed as legal advice, forges a new, more stringent precedent for corporate governance. It demands a zero-trust security protocol integrated into the employee lifecycle itself, a model that vigilantly monitors the dangerous intersection of role changes, data access, and export activity. It treats internal access with the same rigor once reserved for external threats. Consider the battlefield. Rippling, valued at $16.8 billion, claims its entire sales engine was compromised. Deel counters by acquiring SaaS procurement firms and signing global sponsorships like its sleeve deal with Arsenal FC, signaling its scale is undiminished. Both are racing forward, armed with billion-dollar war chests, while their lawyers duel over the definition of a trade secret. The allegations compel a fundamental reevaluation of internal security. This moves beyond digital firewalls to scrutinize the very nature of professional trust. It leaves the industry with an unsettling question. If any employee can allegedly become an instrument of a competitor, how does a company ever build a culture of open collaboration again?